Good morning, everyone, and welcome to our daily briefing on COVID-19. This morning's topic is important participant deadline extensions for group health plans, and I am joined by my colleague, my partner, Mary Bauman. And before we get into our substantive presentation, like normal, let me take you through some of the more important headlines from the last 24 hours. The Michigan legislature has sued Governor Whitmer over her executive orders, alleging that the governor has overstepped her authority. Now, having said that, the Michigan Attorney General did issue a declaration that Governor Whitmer's executive orders are enforceable. Shifting gears a little bit, GM and the UAW confirmed that they are targeting May 18, 2020, as the target to reopen a number of their plants in North America. Michigan is now reporting over 45,000 confirmed cases of COVID-19. And finally, Governor Whitmer extended her executive order expediting unemployment benefits. With that said, we will get going with our presentation. Moving right along. Today's topic, as you may have heard, the Department of Labor, in conjunction with the IRS, has issued a number of extensions that relate to employee benefit plans. As you will see as we work through our materials today, most of these extensions relate to actions that participants in these group health plans have to take. And while these are favorable extensions for participants, we do suspect that they will cause administrative burdens for employers who sponsor those employee benefit plans and possibly also third-party administrators that they use to assist with the plan's administration.
Hey, Tripp, it's Mary. You may be going to address this already, but I think one of the questions we had ahead of time was, hey, this is all about DOL, IRS, and ERISA. What about a non-ERISA, for example, governmental plan of a state or municipality? Do they have to comply with these new rules?
The great question, Mary. The answer to that question the short answer is yes. These DOL, IRS regulations don't directly apply to these non-federal or these health plans sponsored by non-federal agencies because they fall outside of the Department of Labor and the services jurisdiction, but they do fall within the jurisdiction of Health and Human Services, and Health and Human Services has indicated that it will also comply and enforce these deadline extensions.
Thank you.
No problem. Moving on. So the extensions generally relate to HIPAA Special Enrollment Periods. As you will see, a number of COBRA deadlines have been extended. Benefit claim and appeal deadlines have been extended, and that's really where actually some of the extensions are not only applicable to group health plans, but also to all ERISA employee benefit plans, retirement plans, other welfare plans. And then finally, there was some Form 5500 and Form M1. The Form M1 is filed by multiple employer welfare arrangements, or there were some filing deadline extensions. However, as we will discuss, those were not really meaningful extensions. Next slide, please, Jeff. So throughout this presentation, we will basically be talking using a term called the outbreak period. These extensions or periods are basically extended by the outbreak period. So what is the outbreak period? The outbreak period began March 1, 2020, which is a little difficult because these regulations were not issued for almost 2 months after March 1, 2020. I think they came out on April 27 or 29. I forget the exact date. All the days blend together these days. And I think the other difficult part is it extends out 60 days after the president's national emergency declaration expires. So the big question mark here is we don't know when that's going to be. And frankly, Mary, it may be different for different areas of the country. So, for example, I fully expect the national emergency declaration in North Dakota may expire before the one in New York State does. In that situation, the DOL and IRS has indicated that it will issue additional guidance, and hopefully, if they have to do so, it will be on a little bit more timely basis than these most recent regulations. So I think I guess a way that I envision this outbreak period is on the calculation of any deadline or a time period, you're basically hitting the pause button on that calculation or during that period for any part of that period or deadline that falls within this outbreak period, which again is going to be difficult because we don't know when it's going to end.
Well, and also, Tripp, I mean, I think it's also worth mentioning that the outbreak period hasn't ended yet for any state or locality, and so let's say it ends in June. It's 60 days plus the end of that date, so it's a long time.
Correct. So if it ends June 30, for example, if the national emergency declaration ends June 30, the outbreak period is still going to continue until August 30. So good point. Yeah. Next slide, please. So the first extensions relate to HIPAA Special Enrollment Periods. So as a quick refresher, individuals who are eligible for group health plan coverage but are not enrolled may generally enroll in that group health plan coverage mid-year or outside of the annual open enrollment period following certain events. Those events are first, a loss of eligibility for other group health coverage or other health insurance coverage, as long as that loss was not participant-driven, if you will. So, for example, the participant filing a fraudulent claim for benefits or failing to pay a premium. If they truly lose eligibility for that other coverage, they are entitled to a special enrollment right. The second is an acquisition of a new spouse or dependent by marriage, birth, adoption, or placement for adoption. Jeff, next slide. The loss of eligibility under a Medicaid or CHIP, which is Children's Health Insurance Program, that's what CHIP stands for, or someone who's newly eligible to participate in a Medicaid or CHIP premium assistance program. Quick background on those. Premium assistance programs is where Medicaid or CHIP will basically pay part of your employer's, the premium for employer group health plan coverage. For those of you on the phone from Michigan, Michigan does not have a Medicaid or CHIP premium assistance program, but those do exist in a number of other states.
Right, like at least 40.
Exactly. So generally, individuals must request enrollment within 30 days of these events to enroll in group health plan coverage. However, for special enrollment events that are related to Medicaid or CHIP, you actually have 60 days of the event. From the event to request coverage. Now, an interesting point I think we need to make here, Mary, because this demonstrates where I think employers are going to find their first bout of administrative burden is if a HIPAA special enrollment event is related to adding a new dependent by birth, adoption, or placement of adoption, the coverage actually has to be retroactively effective back to the date of the birth, adoption, or placement for adoption. So as long as I request enrollment within the deadline period, coverage has to be retroactive. On the flip side, if the special enrollment period has to do with a loss of eligibility for coverage or Medicaid or CHIP, coverage is only required to be prospective and has to be effective basically the first day of the month after the participant submits their request for enrollment.
Well, and then another wrinkle on that, Tripp, is in general, I'm not supposed to allow employees to pay required premiums on a pre-tax basis for retroactive coverage, with an exception, of course, being for newly born children. What happens if I, have a loss of coverage and I don't ask you about this to enroll for for another 3 or 4 months? Can I go ahead and pay that retroactive premium on a pre-tax basis? I would think the answer would be yes, but that wasn't specifically addressed by this guidance.
No, and so I think your options there, if your conservative option is, of course, you could make participants pay on an after-tax basis, but if you have a self-funded plan, I don't want to go too far down this rabbit hole. We may have ERISA plan asset issues, but if we have a fully insured plan, allowing participants to pay on an after-tax basis is permissible. And maybe we could just clarify, when we pay for retroactive coverage on a pre-tax basis, we're not actually adjusting previous payrolls. We are just paying for that retroactive coverage out of future payrolls on a pre-tax basis.
Right.
Jeff, next slide. So for purposes of these 30-day and 60-day periods, the outbreak period cannot be excluded. So what I was alluding to before was where we may see the first administrative burden is if someone has a new birth, they have a significantly longer period of time than 30 days to notify their employer of that birth and their request to enroll that new child onto the employer's group health plan. And in the event that they do that, the coverage would have to be retroactive. And maybe we can illustrate this by an example. So Jeff, next slide, please. So shifting gears a little bit, an individual loses coverage under a plan maintained by his spouse's employer on March 31, 2020. Assume that this individual is also eligible for his or her own employer's group health plan. Typically, to enroll in his employer's group health plan mid-year, they would have to request enrollment by April 30, 2020. However, under these new DOL and IRS regulations, the individual may request enrollment by 30 days after the outbreak period. And again, in this example, coverage would only have to be in place prospectively. If you change the fact pattern a little bit and say an individual has a baby on March 31, 2020, the individual would normally have till April 30, 2020 to enroll that new baby in the employer's plan. But again, if we say the emergency declaration ends June 30, now the employee could notify the employer of that
could be in
baby
September.
By August 30, I think would be the 60-day period. And that coverage would have to be retroactively effective back to March 31, which would be the date of the birth. Again, so I think that may cause some administrative burdens, especially if claims are incurred by that child in the interim period there. Next slide, please.
Okay, now we get to the really fun part, and that's COBRA. We expect that there's going to be some big challenges here. The primary ones will be regarding payment, which we'll address in just a minute. But the first is regarding the notice of the qualifying event. So remember that typically a qualified beneficiary has to enroll in COBRA within 60 days. We usually think of it as 60 days of the qualifying event, meaning the day they lose coverage. But don't forget that if you don't get the COBRA notice out in time, it's 60 days from the date the notice is furnished. So in determining the 60-day period now, we cannot look at the outbreak period. Next slide, Jeff.
Hey, Mary, let me just interject here, too. Again, this is one of those retroactive situations where if I elect within my 60-day period, coverage has to be reinstated as the day that I lost. And I know probably many people, I think with this significantly longer period to elect coverage, I think what comes with that is an increased risk of adverse selection.
Absolutely.
For those folks on the phone that know what we call the COBRA game, which is basically, I'm going to wait till as long as I possibly can to elect COBRA, and I'm only going to do it if I actually have a large claim that I incurred, or I potentially elect COBRA and then wait another 45 days to pay for that coverage. And if nothing happens, I don't pay for it. But if something big happens and I have a big claim, then I, of course, elect and pay for COBRA. That COBRA game is now, you can do that for a much, much longer period of time under these extensions.
So here's a great example of the normal rule. So the normal rule, we have an employee that terminates employment on April 15 of this year. Then their coverage actually terminates the last day of the month. And the COBRA election notice for this employee is sent fairly promptly by April 27. Normally, it's 60 days from April 30. That would take us out to June 29. But now they have not just till June 29, they have 60 days until the end of the outbreak period, till after the outbreak period. Next slide, please. So that's a significantly longer period of time, and as Tripp suggested, that does open the door, unfortunately, for qualified beneficiaries to play that COBRA game and only elect if necessary due to claims. In addition, don't forget that participants in certain circumstances have to notify basically the plan if a qualifying event has occurred. We've listed the three primary ones on this slide. So in the event of a divorce, either the employee or the ex-spouse has to provide that notice, or a child attains the limiting age, which is generally age 26, or there's been a disability determination, which you may recall allows the qualified beneficiary to extend coverage beyond 18 months to 29 months. Next slide, please. So again, these 60-day periods are extended as a result of the outbreak period, because the outbreak period cannot be included in determining that 60 days. Next slide, please. And here's an example. Let's say that there's a divorce on February 2. Normally, either the employee or the ex-spouse would have to notify by April 2, 60 days later, of that divorce. And of course, for those of you on the call that deal with benefit administration, you know that this is a problem anyway, right? We oftentimes have spouses and employees fail to give us that notice. But now, under the new guidance, the employee or the ex-spouse would have to notify, and here's a little bit of math here, guys, of how do you disregard the outbreak period. It would be 32 days after the outbreak period ends, because there is 28 days occurring in the 60-day period before the beginning of the outbreak period on March 1. And then if you subtract 60 days minus 28 days, then there's 32 days remaining. So 32 days after the outbreak period ends is when the spouse or the employee would have to provide notice of that divorce in this example. Next slide, please.
And Mary, I think, I added that example specifically because I think that's a good one, a good illustration of basically hitting the pause button on that 60-day period for the outbreak period. And I did get several questions since these regulations were issued. Do I only have to consider these types of events that happen in the outbreak period? And the answer to that clearly is no. If any one of these, election periods or whatnot falls within the outbreak period, there's still gonna be an extension that applies.
Right. So how I kind of look at this is, if it happens before the outbreak period, you're hitting the pause. So you're considering the time before the outbreak period and after the outbreak period. So March 1 is, of course, the beginning of the outbreak period. But if the event happens during the outbreak period, then you're basically getting the full benefit of whatever the time parameter is, 30 days, 60 days, whatever. So that's kind of how we look at that. Okay. So the next issue, and this, guys, I don't know, Tripp, if you agree with me, but I think this is really where people are going to be tearing their hair out, and this is, I think, the most challenging addition regarding COBRA premiums.
No, I do agree with you.
Yeah, so remember that under COBRA, there is a requirement to pay your initial premium within 45 days after you, the qualified beneficiary, elect coverage, and you have up to 60 days to elect coverage. So we have that potential of 105 days that the qualified beneficiary can elect and then pay for his or her initial premiums. And many times individuals will take full advantage of that 60 plus 45 day period to see if they have any claims, whether they need to elect and pay for COBRA, right? So that's the first rule. And then the second rule is that for monthly ongoing premiums after the initial premium, and the initial premium is for the coverage elected during that window. So it's not just the first month, right? It could be the first like 3 months or whatever. And then after that, their ongoing monthly premiums are due on the first day of the month with a 30-day grace period for timely payment. So before all of this guidance came out, what did we know? What we knew was that the plan, could be the insurer, could be the self-funded employer group health plan and the plan administrator, but the plan had a couple of options. One option for, let's first go with the initial payment. But one option would be to say, okay, you elect COBRA and you elect it, let's say, on the 59th day. At that time, I'm going to actually enroll you in coverage retroactive to the date of the qualifying event, and I'm going to cross my fingers and hope you make the initial payment. That's a very common way to do it. But alternatively, I could wait to enroll you until after you make that initial payment and make it timely, and then I am going back and retroactively enrolling you back to the date of the qualifying event. Now, why would you want to do the second way? Obviously, you want to do the second way because you don't have to outlay any premium until the employee, the qualified beneficiary, actually pays for it. But sometimes what we've seen is employers don't do the second way because their insurer, if they're fully insured, or their stop loss carrier and TPA, if self-funded, will come back to them and say, we will only accommodate retroactive enrollment for a limited period of time, maybe up to 60 days. So if you need to go retro, let's say 3 months, we're not going to accommodate that. So you better elect the first way because that's the only thing we're going to allow you to do. So it's an underwriting pushback. It's not a legal pushback. Similarly, with the ongoing monthly premiums, don't forget that, yeah, same thing. We knew up until now that if I didn't pay on the first day of the month, I could terminate their coverage, and then if they paid within the 30-day grace period, retroactively reinstate, or alternatively, I could wait to terminate until the 30-day grace period expired. So both of those methods are okay under existing guidance. Next slide, please. Now, what the DOL has done in issuing this guidance, because this particular rule kind of, I don't know, Tripp, would you say it kind of was a little bit of a firestorm? I mean, this is a big deal. And the DOL has already been asked about this particular rule, and we've learned that the DOL has informally advised that those same rules apply in the present case under this new guidance. And so if somebody doesn't make their COBRA payment, you could, like let's say with an ongoing monthly premium, you could terminate as long as you retroactively reinstate. And I think the same logic would apply for that initial premium payment. But again, if you're going to take this approach, you need to make super sure that your insurer or your stop loss carrier is going to play ball with you if come to find out that you have to then go back 3 months and retroactively reinstate coverage. And I think, Tripp, the interesting issue will be, what if an employer innocently or intentionally doesn't go over that with their carrier and then has this issue? Will the employer still be able to prevail by saying, hey, you have to do this because it's required by law? Or will the carrier prevail because they have the right to set underwriting rules? What do you think?
That's an interesting question, and I would say here's where we really got to bifurcate between a fully insured plan and a self-funded plan. I would say with a fully insured plan, the employer has a much better argument because these regulations apply not only to the group health plan and the employer, but the carriers themselves. So you would have, the argument that, hey, these tolling of these election periods or payment periods or what have you apply to you from a legal standpoint just as much as they apply to me. Now, with a self-funded plan, of course, these regulations apply to the plan itself, but stop-loss carriers are not subject to these regulations unless, for example, a state insurance agency gets involved and said, we're going to basically carry over these regulations and apply them to stop-loss carriers. So while you probably want to communicate with your insurer anyway, I think it's probably even more important if you are a self-funded plan to, affirmatively and actively engage your carrier and say, listen, are you going to honor these periods? And I would say, what I have seen, Mary, and I think probably the same is for you, is where sometimes we would see pushback, more pushback from stop-loss carriers in light of this COVID-19 pandemic. They have seemed to be more willing to make certain exceptions because of this, because of this pandemic.
Yeah, and I do think, guys, if worse came to worse, you could always say, hey, well, you know what? I'm going to just call the Department of Labor, or I'm going to call my state insurance regulator and complain about this. And you know what? That might be just enough pressure to force that carrier to come to the window. So not all is lost. Tripp, I think it's your turn.
Yep. Next slide, please, Jeff. So here is just an example of what Mary kind of went through. We have a qualified beneficiary's COBRA premiums due on the first day of each calendar month. Of course, the qualified beneficiary has 30 days after the first of the month, which is the grace period to make that COBRA premium. If the individual fails to make the COBRA premium by the first day of the month, COBRA coverage is terminated. And again, that is permissible, as we'll see. Next slide, please, Jeff. As long as if that payment is made, timely made, coverage is reinstated retroactively. So normally, if the qualified beneficiary paid the COBRA premium within the 30-day grace period, the COBRA coverage was retroactively reinstated. Again, and some employers may not terminate coverage during that period. They'll just wait until after the grace period deadline. Either approach is permissible, and you may want to talk with whoever you're doing your COBRA administration, because I understand that those processes are largely automated, and changing those automatic procedures to address these regulation changes is going to be difficult. Having said that, under the new DOL regulations, the individual's coverage must be retroactively reinstated, as long as the qualified beneficiary remits all delinquent premiums by 30 days after the end of the outbreak period. So again, if we assume that the outbreak period ends the emergency declaration ends June 30, the outbreak period would not end until August 30. So a qualified beneficiary would basically have, until I believe probably September 29 to remit all of their delinquent COBRA premiums. And if they did so, and coverage had been terminated, it would have to be retroactively reinstated. Next slide, please.
And that's where the challenge is going to be with the carrier.
Yep.
Potentially.
All right. Well, not all of these extensions were directed just to participants. There was one olive branch to employers, and that is the 14-day period in which a plan administrator must provide a qualified beneficiary with an election notice after receiving notice of a qualifying event. So again, as Mary talked about earlier, if the qualifying event is a divorce or a dependent child attaining the limiting age, the individual is going to be providing the employer or plan administrator with a notice of that qualifying event, which they typically have 60 days to do. Now, again, that 60-day period was extended, and the outbreak period cannot be included in determining that 60-day period. But after receiving that notice, the employer or plan administrator has 14 days to provide the qualified beneficiary with their election notice. Next slide, please, Jeff. Similarly, if the qualifying event is the employee's termination of employment or reduction in hours, the employee's death, the employee becoming eligible for Medicare, or the employee's bankruptcy for retiree coverage, the qualifying notice is not in that situation provided by the individual, it's provided by the employer. And the employer has 30 days to provide this qualifying event notice to the plan administrator.
And since the plan administrator and the employer are really kind of one.
Mary's getting ahead of me here. So let me just point out that this 30-day period was not extended under the regulations, but practically that may be a distinction without a difference. Next slide, Jeff. So this is what Mary's alluded to. So the outbreak period cannot be included in determining the 14-day period. However, in most single employer plans, the employer is both the plan sponsor and the plan administrator. So the employer typically has 44 days to provide qualified beneficiaries with the COBRA election notice. And you derive that from adding the 30-day period that the employer must notify the plan administrator, and then the 14-day period that the plan administrator must notify the qualified beneficiary. So while the 30-day period is not extended, the 14-day period is extended, and it gets you kind of the same outcome.
Tripp, as a practical matter, do you think don't you think most employers would say, hey, let's just get it going on the COBRA notices? I don't know if it really is that important. I mean, I think there's always inadvertent mistakes, right? But I think most employers are like, let's get this COBRA thing going.
Especially to the extent that, hoping that maybe those qualified beneficiaries will make what would ordinarily be timely elections and make premium payments to try to avoid those, retroactive coverage, long periods of retroactive coverage situation. Absolutely. I anticipate most employers will still try to get these election notices out ASAP. Yeah. Next slide, please, Jeff. So just an example here, an employee's employment is terminated on March 15, 2020. Typically, the employer must provide the COBRA election by April 28, 2020. However, since the 14-day period cannot include the COBRA outbreak period, the COBRA election period actually can be delayed as long as it is provided within 14 days of the end of the outbreak period. Let me just note here, I think, this is kind of when I think we're going to shift gears on the next slide away from COBRA elections, but all of these extensions can somewhat have a cascading effect, I think. I mean, the participant has a longer period of time to notify the employer of a qualifying event, an indefinite longer period of time. Then the employer has an indefinite period of time, at least at this point, to provide the election notice. And then you turn around again, and the employee, again, we don't know the end of the outbreak period, has a longer time both to elect and then pay for COBRA. So if the employee waits until the 60 days after the end of the outbreak period to notify the employer of a divorce, then we're just building on those periods out there. So anywhere kind of in that train, we can have these substantial delays.
And don't forget that stop loss carriers and insurers are not going to let any catastrophe go without benefiting from it. So I could see, Tripp, let's say I have a calendar year plan and I'm coming up for renewal in the fall. I can see the stop loss carrier or the insurer, if I'm a large group and I'm experience rated, saying to me, well, how many people haven't, elected COBRA yet because of this? Or how many people have elected but haven't paid yet? And having that somehow adversely impact their renewal quotes. I can see that happening.
Absolutely. The time will tell, but I would not be surprised. Next slide. And I think, Mary, it's back to you on benefit claims.
Yeah, so here, this is our last big topic, guys, and this is the third kind of piece of the regulation, and that is that you can't include the outbreak period in determining any benefit claim deadlines. Now, this is one exception. To this morning, we're really focused on health plans, and the guidance clearly is focused on health plans, but this is also applicable to other plans, including disability plans and retirement plans. It also applies to medical flexible spending accounts and HRAs. So let's say, for example, you are the classic Section 125 plan operating on a calendar year, and your medical FSA claims must be submitted, let's say, 90 days after the plan year ends, or by March 31 after the plan year ends. Since that occurs after the beginning of the March 1 outbreak period, that effectively postpones the claims deadline for medical FSA claims, and it could be until sometime this summer, right? I mean, so that's just something to be aware of. Next slide, please. So just to kind of refresh your memory, so first we've got the claims filing deadlines by the participants, which are postponed. And then remember, if I submit a claim and it's denied, that's called an adverse benefit determination, and then I have a prescribed period of time in which to file an appeal. So for a health plan or a disability plan that's subject to ERISA, that's an 180-day period to file an appeal of an adverse benefit determination. For non-health, non-disability plans like a retirement plan, it's 60 days. And again, the outbreak period cannot be included in that 180 or 100 or 60-day period. Next slide, please. I think we have now an example of how this would roll. So let's say, and again, this is going to be an example of where the deadline is interrupted by the outbreak period as opposed to the initial event occurring during the outbreak period. So let's say that I receive my adverse benefit determination of a group health benefit on February 20 of this year. Usually, I would have to submit my appeal by August 18 of this year, 180 days later. Now, since the outbreak period can't be included, I first look at the 10 days happening before the outbreak period started on March 1. I don't know if we did the math right on that trip, but anyway, 10 days, and then I would tack on the remaining 170 days after the outbreak period ends. So basically, again, as Tripp pointed out, it's kind of like a pause button. The appeal period started to run on February 20, it paused, it stopped on March 1, and then it resumed again, the 180 days resumed again when the outbreak period concludes. Next slide, please. And then similarly, retirement plans, so like let's say a 401k plan or a pension plan, must also have, they have a 60-day deadline. And here's an example where the 60-day period started actually on March 15 during the outbreak period. So I received my claim denial on March 15. Typically, I'd have 60 days from there until March 14. Since both of those two dates occurred during the outbreak period, I basically have until 60 days after the outbreak period ends to submit my appeal. And next slide, and Tripp, I think this is you.
It is. So for those of you that have non-grandfathered group health plans, one of the requirements under the Affordable Care Act is that you offer participants the opportunity to request an external appeal by an independent review organization of certain adverse benefit determinations. So for example, if a claim was denied based on medical necessity, that would be an adverse benefit determination that would be eligible for an external review by one of these IROs. Conversely, if a participant's request for enrollment in a group health plan was denied because the employer determined that employee was not actually eligible for the employer's group health plan, that would not be while that would be an adverse benefit determination, would not be one that is reviewable by an IRO on an external basis. So generally, participants must request an external review within 4 months after receiving the adverse benefit determination. Next slide, Jeff. Also, if a participant's external review is incomplete, so they didn't have all of the information necessary in order to perfect that external review, the request for the external review, the participant must correct that you must correct that error and complete the request either by the later of the original 4-month period in which the request was originally due, or within 48 hours after the participant files the request for review. Probably not surprisingly, neither this 4-month or 48-hour period can include the outbreak period when you are calculating it. Next slide, please, Jeff. So here again is an example: a participant receives an adverse benefit determination of his initial appeal. So they filed an initial appeal of their adverse benefit claim, and they received a determination on that appeal on April 6, 2020. At this point, the participant could choose to request an external review rather than proceeding directly to litigation, but the participant must request that review, external review, typically by August 6, 2020. Under these new regulations, the participant has until 4 months after the end of the outbreak period to request that external review. Next slide, please, Jeff. Finally, shifting gears one last time, there is some Form 5500 and M1 filing deadline extensions. However, as you can see, they are not incredibly meaningful at this point for most plans. But we may, I think, in the future, Mary, get some further extensions of this.
Yeah.
There's no guarantee in that, but I wouldn't be surprised. So forms, again, just to cover, if you are a multiple employer welfare arrangement, you're required to file a Form M1. That's probably, that's a minority of plans, probably minority of people on this call, but Forms 5500 and Forms M1 that are due between April 1, 2020 and July 15, 2020 are due just simply on July 15 of 2020. Again, this provides very little relief for 5500s for calendar year plans, which are due. The unextended deadline is July 31, 2020, which does not fall within this April 1, July 15 timeline. So that unextended deadline does remain at July 31, 2020. Now, of course, just like every year, those 5500 deadlines can be extended. The annual Form M1 filing requirement is due March 1, so that already happened. So that was not extended, but for newly created MEWAs or for certain MEWA plan changes that change the information, typically a new M1 has to be filed within 30 days. If that deadline falls between April 1, 2020 and July 15, that deadline is extended to July 15. Next slide, please, Jeff. All right, we do have some questions, Mary, and I've got some chat out of the chat window, so we will move through those. I think probably I'll kick this one to you. I think probably the most common question that we're getting is, what, if anything, needs to be communicated to these employees regarding these extensions?
Yes, I think this is a huge, huge question. The guidance didn't say anything about participant communication requirements, which is very interesting. And then the other thing that's very interesting to note for some of you who are super geeky and keep up on all these developments is that I believe it was either the same day or the day after this guidance came out, the Department of Labor also issued a new model COBRA notice. And in that model COBRA notice, they basically made a small change to add a new section better explaining the connection between COBRA and Medicare. And there were some FAQs that were also released as part of this. And in the FAQs, they did acknowledge that these changes were being made as a result of two individuals who were representatives in Congress who'd asked for clarification on behalf of their constituents. So what's interesting is there's been some commentary already released out there where folks are saying, well, if there was a communication requirement, why didn't the Department of Labor say anything about it when they issued this new model notice in the FAQs? That must mean that there is no notice requirement. On the other hand, both Tripp and I suspect that this model update was in the works before maybe this guidance was even worked on, and as a result, it might just be nothing more than coincidence. And yet, why didn't they say, for example, in the FAQs, oh, more information will be forthcoming on any participant communication requirements when, later. They didn't say anything about it. They were silent. So I would say that right now, based upon the guidance that we have, I would say that there really probably the better argument is that there isn't a notification requirement. Having said that, and also because it's, temporary, and we had the COVID guidance that we've received so far has definitely been, I think, accommodating to plans in terms of participant notification requirements and giving you some flexibility. If you use, for example, a COBRA administrator, you might want to think about working with them to provide some type of communication so people understand it, that you're not hiding the ball. But would I say you have to run out and prepare SMMs this moment? I guess I would say no. I think he who acts quickly is often penalized in the world of employee benefits, and he who waits often gets away with it. So I would probably be inclined not to do that. Tripp, what do you think?
I agree with everything there. I would say I would be hesitant to rush to modify notifications or do SMMs until we learn, if and when we learn affirmatively that we have to do so. One other question that we got from before the webinar, Mary, which I will address because I think we answered it during our presentation, is can employers temporary term COBRA coverage for beneficiaries who don't timely pay their premium and reinstate if paid within the grace period? The answer to that question, I think, as we addressed, is that is permissible under the DOL regulations. However, that is going to bring up retroactive reinstatements, and you may want to communicate with your carrier or stop loss carrier about those retroactive coverages or reinstatements. Moving on to some of the questions that we've gotten on live is for a qualifying, so now we're talking about special enrollment events to add health insurance. Can we add coverage as of the date of the special enrollment event? We understand that sometimes coverage can be added prospectively no later than the first day of the month following the request, but we want to be uniform. The answer to that question is yes, you can do that. However, remember, I think this puts you back into that situation of retroactive coverage, and for special enrollment events that are not a birth, adoption, or placement for adoption, theoretically you cannot allow those, the cost of that retroactive coverage to be paid on a pre-tax basis.
Right, and also, Tripp, I would say that since that is more generous, you would want to make sure that the carrier was on board with that as well, because the last thing you'd want to do would be to be nice and do that and then have a catastrophic claim and end up having to totally self-fund that claim because your insurer or stop-loss carrier objects.
Correct, absolutely. And just to kind of round out the thought on that, if you're fully insured and you're offering that and that is permissible, I think you have the option of either taking premiums for that coverage on an after-tax basis, or waiving the coverage requirements. If you are a self-funded plan, because of ERISA plan asset issues, your only option may be just waiving the cost of that retroactive coverage, again, which would be permissible as long as it's done uniformly. Next question we have here is, in a divorce example, does coverage retroactively end, or do they keep them on insurance longer? So I think this is, again, a COBRA qualifying event question in the case of a divorce. And I think an employer has options here. They could potentially keep, the spouse on coverage until the end of the 60-day period or the initial payment window. But I think kind of the more common approach is that coverage would be terminated when the employer learned of the divorce, and should the qualified beneficiary, who is the ex-spouse, later elect COBRA coverage and pay for that coverage, it would be retroactively reinstated. Do you agree, Mary?
Yes, I agree.
All right. Next question: will this rule pertain to all coverage offerings? For example, dental, vision, life, disability, FSA. The COBRA, for example, the COBRA extensions are going to apply to all plans that are subject to COBRA. So that would be dental, vision. The FSA would not apply to life or disability. However, the claim deadline extensions would apply to those life and disability plans that are at least subject to ERISA. So if you take the position maybe that your voluntary life and disability plans are exempt from ERISA, then I'm not so sure, Mary, that the extensions would apply for benefit claims.
I agree. And the other interesting one there that isn't asked but is inferred is dependent care FSAs. Dependent care FSAs are not subject to ERISA. Do you really want to say our normal claims filing deadline applies for dependent care and the special COVID one applies for medical FSAs? I mean, I guess you could do that, but that's kind of an interesting little phenomenon as well.
Absolutely. So these next two kind of questions go together, and it's can you speak more to how this affects FSA plans, and how it does or does not extend plan year deadlines? For example, if a plan year ends on 6/30/2020, and also our flexible spending account grace periods also extended. So my answer to this, Mary, is it certainly doesn't extend the plan year with respect to when claims can be incurred, and that would be the same also for grace periods. It does not extend the grace period from when claims can be incurred for which requests can be a reimbursement, but those claims filing deadlines.
When we're talking about the 2.5 month, we're talking about the 2.5 month grace period.
Grace period, yes, that would not be extended, but those claim filing deadlines, which we often refer to as run-out periods, those are what's expended. So, for example, if I have to submit claims within 90 days after the end of the plan year or the end of the grace period, those 90-day periods, run-out periods, would be extended, but not the end of the plan year, not the end of the grace period.
Right. So if my plan year ends on June 30 and I have a 90-day grace period that puts me out until the end of September, if that falls outside the outbreak period, that employer does nothing different in terms of its claim submission period for that FSA program.
Okay. Do we have to make plan document changes? Interesting question. I would say, this kind of goes along with the requirement to whether or not we need to answer or notify participants of these extensions. I don't think at this point plan document changes are required because, these certain limitation periods are still in effect. We're just legally required to toll them, if you will.
Right. Yeah, I agree.
Again, we've gotten a lot of the FSA questions. Again, the period for which FSA is, just to reiterate, to incur claims, that is not extended, but any run-out period to submit those claims for reimbursement is extended. Is the requirement to doing post-tax contributions for retroactive enrollment only for those who roll past 30 days. I would say no. Again, we're back into the HIPAA Special Enrollment rights. And again, we're not talking about birth adoption or placement adoption. We're talking about those other ones. Anytime you have a retroactive enrollment, if you're going to charge a premium, so even if it's within the original 30-day period, but coverage is going to be retroactively reinstated, arguably Section 125, would not permit pre-tax contributions for that retroactive coverage.
And that is true, Tripp. And we're both parents, so we know that we sometimes hear, well, everybody else is doing that, though. We hear that at home. And I will be the first one to admit that it is very common for employers to allow retroactive enrollment. And even if it isn't for a circumstance which is birth, adoption, or placement for adoption, they typically will collect those premiums on a pre-tax basis. Technically, in those circumstances, not permitted by 125, but I haven't ever seen the IRS audit on that.
Well, I suppose you could make the argument that they were still after-tax contributions through a Section 125 plan, but I think your Section 125 plan should allow after-tax contributions in those situations, which, frankly, Mary, I've never seen.
I've never seen either.
For non-calendar year plans, our open enrollment period, annual open enrollment periods extended. Under these regulations, no, they are not.
Nope.
They do not address annual open enrollment periods. What about FSAs? Can contribution change take place as of the next payroll date, or does it have to be retroactive and post-tax? Dependent care too. Nothing in these regulations address changes in FSA contributions. We still have to have a permissible mid-year change event under Section 125, and generally when we have those, any changes in FSA contributions would be prospective only. I think I'm not aware of many, if any, situations in which those FSA changes can be retroactive.
Right.
Here's an interesting question, Mary. I'll kick this one to you. Would any of these extensions apply to wellness plan deadlines? For example, an annual physical is due by June 1. Would the due date be extended 30 days past the outbreak period?
I don't think that is intended to fall within the scope of this guidance, because the only area that would arguably be applicable is the extension on claim submission. And is that a claim submission? I don't think so. It's a requirement to comply in order to get a wellness benefit. Having said that, I have spoken with many employers in the past couple of weeks who have wellness program deadlines, and they're worried about how that's all going to shake out in terms of COVID and how to get some of these things done. So we've had a lot of clients looking at modifying their requirements to make it easier for employees or waiving requirements in order to just practically get this done. So I don't think that the guidance necessarily mandates that, but I think that the realities of COVID may make it very appropriate for the employer to waive or modify their deadlines to make them work.
I guess, Mary, my only comment on that, and I'll throw it to you to see if you agree, if the wellness plan was an ERISA plan and had some type of claim filing deadline, then that would be extended.
Right.
Okay, last question that we have, and it really actually is a great question. It relates to kind of the 90-day run-out period, or any period run-out period in connection with the $500 carryover. So remember, some plans don't use a 2.5-month grace period. They allow employees in a medical FSA to carry over up to $500 from one plan year to the next. And I think the question is I think really this is an administrative question or another administrative burden, Mary, because oftentimes if you have a run-out period, you can't properly calculate the carryover amount until the run-out period is done. So again, nothing in these would extend the period that participants could incur claims in a previous plan year. It may just delay the time in which a participant, or in which a plan administrator of an FSA can calculate the actual carryover amount, because they may have a significant longer period of time before they know about claims in the previous plan year. But I don't know if I have a great answer with that. I think that is a conversation that you may have to have with whoever administers your FSA, or simply you're going to just have to, not calculate the carryover until, we get to potentially way later in this year. Now, having said that, I think in situations like this, where many individuals are off from work and not being paid and maybe only collecting unemployment, I think this is a situation where many of them are probably not going to unnecessarily sit on unpaid FSA claims for an unnecessarily long period of time. I think, they may want that money as soon as possible. So hopefully that alleviates some of those concerns. Right.
And we know that probably they haven't incurred any claims since March, beginning of March.
Exactly. And with that, we've answered all of the questions. It's 9 o'clock, so I think we will sign off. Thank you for everyone for attending, and we will hopefully see you soon. Take care.
Yep. Take care. Bye-bye.